I understand it's an enormous cost for the community. It's estimated at almost $3.4 billion a year, the costs associated with family violence, which is equivalent to road trauma. We know it makes up about 30% of our assault offences, 30% of property damages, and also 43% of murders.
You're watching The World from Below, and that was a clip of Police Commissioner Ken Lay talking about his commitment to do more about family violence when he first came into the role. We move now to discuss the experience of women in the justice system as victims of family violence and sexual assault. Offences associated with family violence make up a significant part of crime rates statistically. The issue of family violence has been on the political agenda here in Victoria in the lead up to the state election, with community organisations calling for a range of reforms and the government promising to spend $150 million on tackling family violence if re-elected in November. This is an area of criminal justice that's well suited to the idea of restorative and therapeutic jurisprudence. Bronwyn, can you explain what those terms mean?
So therapeutic jurisprudence is the broader topic, I think, and therapeutic jurisprudence is really based on the idea that legal systems should do as little harm as possible and preferably should actually be therapeutic, that there should be something that's capable of healing the wrong that's been done, I guess, by the justice system itself. So it's initially developed in relation to mental health issues and the way in which the criminal justice or the justice system managed people with mental health issues, where it was clear that getting involved with the justice system made things worse for people, and people started looking at alternative ways of managing those issues. It's been developed in a number of ways, one of which is what's referred to as restorative justice. So restorative justice draws on this notion that it's possible to have a therapeutic justice system, but restorative justice in particular looks at alternative ways of managing the relations between people, which...
you mean the victim and the offender?
Yeah, between the victim and the offender, which is different from an adversarial justice system. I'm thinking here particularly of the criminal justice system. So the concept really is based on the idea that for offenders it can be a lot more educational, a lot more rehabilitative, if they actually face the victim, the person that they've harmed, and can understand, develop empathy, get a sense of what it was that they actually did to that person. And for the victim, in some cases, and I'd emphasise this is for some crimes and for some criminals and for some victims, not for everybody, but it identifies the fact that for some victims, the criminal justice system doesn't really offer them a lot. So even if they do go to court, even if there's a conviction achieved, they may not feel that really their own harm, their own pain has been addressed. And what's been found is that in some situations, in the right sort of situations where people are willing to participate in this, offenders can develop empathy, can actually get a different understanding of what they've done and how they've behaved, to the extent that they may actually be transformed and changed and choose not to work in that way in the future. But also that victims, once they can face the offender and have the offender explain to them, a question which victims often want to know is, why me? Why was it me that you assaulted? Why was it my house that you burgled? And what's often the case is that in fact it was completely opportunistic, and it's very important for victims to know that it wasn't their fault. So those sorts of experiences of restorative justice can be extremely healing in the right situations.
What does that look like in practice for you, Pauline?
Therapeutic jurisprudence for me on a day-to-day basis in the court, say in a family violence matter, will mean that as well as looking at a punishment, we may also look at how we can work on the underlying causes of offending. So looking at how the process of the sentencing can actually have a therapeutic outcome or improve the well-being of someone. In particular with men who use violence, if we can work on the use of violence and other risk factors such as binge drinking, drug use, those sorts of mental health issues, social isolation. So if we can work on those issues, we can minimise the risk of future family violence, and then we need to work on the violence, the choices they make around the use of violence. So what that would look like is it may be that the sentence has a punishment component and accountability component. It might be community work, it might be a term of imprisonment, but there may also be a component in that sentence that actually deals with those underlying issues. So it might be doing a men's behaviour change program, or doing alcohol and drug counselling, or linking with a mental health service. So we work on those issues as well, hoping that what will happen is that we can minimise the risk and provide greater safety for the victim. Restorative justice in the Magistrates Court in Victoria, we don't have any programs in the adult court, but certainly in the children's court there is what's called group conferencing, which is a highly effective method of actually providing young offenders with an opportunity to hear from victims about the impact of their crime on the victims, and it is very powerful and very good at actually building empathy in young people, so that they understand that it's not just all about them and their needs, but that actually their crimes have impacts on people, and hopefully that builds empathy so that they don't reoffend, and it's quite effective.
It's interesting because the adversarial system almost works in the opposite method to that, in the form of it's about the offender and the offender's conduct, or the accused I should say, and not necessarily about conducive to the accused admitting that they may have caused harm and coming to terms with that, but actually trying to avoid that admission entirely. So it does seem like that's almost the opposite of the system we currently have in place, and that does open up broader possibilities for victims.
Well, just looking, at the system, like if you look at a traditional sentencing process, you have a person sitting behind their lawyer, and sometimes it's literally behind their lawyer, like you can't see the person, they're kind of hiding behind their lawyer in a way. In victim-offender mediation, they're forced to sit at the table and look across at the victim and hear what the victim's saying to them directly, and that's not easy. So people who kind of say that these methods are actually, soft on crime or whatever, it's not soft. It's actually much more confronting for someone to actually have to take responsibility, and it's very interesting for me watching people go through that process, and how tough it is on them, and how a lot of people want to avoid that because it's really hard to do.
You're watching The World from Below, and we'll be back after this short break to discuss criminal sentencing. Stay with us.